Welcome to the link this week as we continue in January for 2020. And tonight we're discussing a part of law, employment law, and issues that happen in companies and how these two interact. It's true that many conflicts arise from the employment law and issues like contracts. And tonight my guest is Brian Kwame, who is an employment law specialist. Brian, welcome.
Thank you.
Let me start with a general question. How does the employment contract, most people have contracts at work, interact with the Employment Act generally?
Okay, that's actually a very good question. The Employment Act that is currently in force in Uganda was passed in 2006.
Yeah.
And the purpose of that act was to address historical imbalances of power between the worker and the employer. And what the Employment Act tries to do is establish minimum standards to safeguard the rights of the worker.
Okay.
So the Employment Act essentially sets out certain rights and responsibilities on the part of the worker and the employer and says this is the minimum. If between the two of you, you want to create a better relationship, you're allowed to build on this foundation. But if the employer tries to go below that minimum standard, then there is a problem.
So it's above minimum.
Yes, the employment contract essentially is now amending the act to say, let us say I have been offered 21 days of leave in the act, but in the contract I will be given 30 days.
Okay.
So it can improve it to make things a bit better, but the act says this is the bare minimum that any worker in Uganda is entitled to.
So if it's 21 days of leave, I cannot get 19?
No, you cannot get 19.
Very interesting.
Yes.
There's this element, Brian, probation.
Yes.
You are given a job and given some, so to speak, time for testing you to see if you're up to the job.
Yes.
How long can I stay on probation?
Okay.
And what happens once it's done?
Right. Now, I look at probation as the first phase of a three-phase employment relationship.
Okay.
Probation is when you're entering service. Then there is the duration while you are an employee. And then the third phase is when the employment relationship is being brought to an end.
Okay.
Now, what is critical with probation is that is the opportunity for me, the worker who is being employed, to acquaint myself with the organization and say, am I at home here? Does this organization espouse the values and pursue the same goals that I am interested in? And similarly, it also gives the employer the opportunity to also examine Brian and say, is Brian a good fit for this organization?
Okay.
Right. And the law, the Employment Act says, we are putting a limit on how long this exploratory period can be, and the limit is 6 months.
Okay.
Now, like I said before, that is the minimum standard. Some employers say 6 months is too long for us to know whether we want Brian around or not. Let us have a probation period of 3 months.
Okay.
Such that after 3 months, both parties are set free to decide, are we doing this for a longer period of time or not?
Yeah.
Exactly. So the maximum probation period is 6 months, although there is an exception where if at the end of the 6 months, the employer feels that Brian has not really measured up, but I feel that he has potential. Let me give him a little bit longer to prove himself. And that is when the employer, the act puts an obligation on the employer, sit down with Brian and agree. Brian has to consent to this.
To the extension?
To extend the probation. What used to happen under the old law is the employer would simply write a letter and say, we're not satisfied with you, we're extending your probation for another 6 months without the requirement of consent, yes. But now under 2006 Act, there must be consent from the employee. The employee can say, okay, I agree to another 6 months or another 3 months, or make up your mind today, I have other offers that I can explore. So
now the 6 months are over, let me say, going by the law. And I'm not confirmed, now what?
Well, confirmation is tricky. In the ideal situation, you're supposed to get a letter. You're supposed to be assessed towards the end of the probation and get a letter saying you've been confirmed in the position.
Okay.
But this has been interpreted by the Industrial Court of Uganda to mean that if at the end of the 6 month period, let us say today is the 14th of January. If my probation had ended on the 13th of January, I left office and then showed up today at NTV offices. And then I worked today. And my supervisor does not say anything. My overheads do not say anything. The industrial court has said that, without even a written letter to me, amounts to confirmation of me in the role.
So when probation ends, the employer must say, stay away if there are any issues.
Exactly.
If they allow you to work.
Exactly. And there have been so many cases where the employer wakes up about a week later and says, by the way, your probation ended last week.
Leave.
Come for an appraisal. And then after the appraisal, they tell you leave. And yet the industrial court has said, no, this person is fully confirmed. If you tell him to leave, that amounts to a wrongful termination.
We are coming to that in a moment. Now, termination and dismissal. We're having a prior discussion with you and you said termination and dismissal are different. I thought they were the same.
Well, they are the same if you read the Act from cover to cover.
Okay.
But if you limit yourself to Section 2 of the Act, which now provides the definition of these two terms, there is a complete difference between the two.
Okay.
Okay? What the Act says is, if you're terminating an employee, what you're telling that employee is, Brian, we are happy with the way you conduct yourself in this organization. We are happy with the work that you're doing for us. But because of certain conditions that are external to you, perhaps the organization has lost funding, perhaps you're performing a job that has been overtaken by technology. We're bringing in apps to do this kind of work.
Robots.
Yes, robots. Because of this, nothing to do with you. Because of these external developments, technology, funding, etc., we have to let you go.
That's termination.
That is termination. There is absolutely nothing wrong with you. And if all things were to remain constant, we would work together for the foreseeable future. That is termination. Now, when we come around to now understand what is dismissal, dismissal means all other factors remaining constant, you are the problem. Brian, we either have a problem with the way you conduct yourself in the organization, or we have a problem with the way you perform your job. I call this the 2 C's. C number 1 is conduct. Your conduct is not acceptable to us. C number 2 is your capacity to do the work is not satisfactory to us.
Okay, very nice. So viewers, dismissal and termination, a bit different. I was surprised actually when Brian told me. Now, Brian, let's move on. Minutes are just running away. Wrongful dismissal, that element, you talked about it. When does it occur?
Right.
And what happens in case it happens?
Okay. If I take you back to what I said at the beginning, the Act sets out the minimum standards of how an employee should be treated by the employer. So wrongful dismissal arises under 2 categories. Category number 1 is substantive, let's say departure from the Act. And the second category is procedural departure from the Act. That means if the employer wants to get rid of Brian and has a good reason to get rid of Brian, but does not follow the right process, that is now the procedural irregularity. Let us say does not call Brian for a hearing where they table the problems and say, Brian, because of A, B, C, D, we have an issue with you and we want to fire you. What do you have to say for yourself? And then now Brian has an opportunity to say, thank you for telling me how you are seeing the situation. Let me describe it from my perspective and explain myself and explain my conduct. And then once Brian gives that explanation, the employer might say, oh, okay, we had not seen it that way. We have decided not to dismiss it. Or we have seen what you're saying and we still think you're being unreasonable in the way you're looking at the situation. And I'm sorry, this relationship has to be brought to an end. So that is one of the procedures that an employer must follow, even when it is summary dismissal. Under the old Act, summary dismissal was summary. I don't like you, you've done something I do not like, out.
So not dismissal without a hearing.
Exactly. Even when it is summary. The Act says even when it is summary dismissal, ask Brian to come in, explain to him why you want to summarily dismiss him.
And hear him.
Hear him, and then summarily dismiss after. So that is one of the procedural issues that have to be followed. Another problem that employers actually have when they're carrying out dismissals procedurally is even the hearing itself is not carried out in accordance with the rules of natural justice. The rules of natural justice means the committee that is hearing that the employee is fair and is impartial. It is hearing the complaints from the employer and is hearing the employee's side.
They are neutral, kind of.
They're supposed to be very neutral. But what usually happens is the committee itself starts interrogating the employee and start pointing out finding fault with the employee. And once you do that, then that means the committee is also on a mission.
Prosecutor and judge.
Thank you. the committee is on a mission to kick Brian out of the door.
Anyway.
Yes,
Okay.
and that hearing is supposed to have minutes, and once these minutes are taken to the industrial court, and the industrial court reads the minutes and sees, actually this committee was not being impartial, this committee was out to get Brian out of the door.
There are problems.
There is a problem. So those are the procedural irregularities.
Okay.
The substantive irregularities is when the employer fires an employee and yet there is actually no basis whatsoever that is just in law for firing.
There's no
yes.
proof even.
For example, let us say you say, I've just hired this madam, then I found out she's pregnant. She's only worked for me for 2 months and yet she's going to ask for maternity leave of 60 days.
Yeah.
Let me fire her very quickly before she delivers the baby. The Act says no, that is unfair.
Time is catching up with us in 1 minute.
Sure.
Brian, if I'm compensated in case I get an injury, can I say the money is too little? Can I object to the amount?
You may not be in a position to object to the amount because the amounts are fixed by statute, the Workers' Compensation
by law,
Act.
yeah.
However, what the Workers' Compensation Act provides for is whether the injury is my fault or the employer's fault, this is the amount of money I receive. But in a situation where I have been injured and been given this amount and I feel it is not enough, and the injury was because of something my employer did wrong, not something that I did wrong, the Act says receive this money and file a separate case and get additional compensation over and above this amount.
Okay.
Yes.
Thank you, Brian. We cannot exhaust these issues in these few minutes, but we scratch a little bit. So for you, employers and employees can be in the know of what you are supposed to do. You had the lawyer there, employment law specialist, describing us the few areas we chose. It means that you have to go to the law and see it for yourself and do a little bit of study so that we can have harmonious relationship at work. That was the link this week.